Diplomatic immunity is a status granted to a diplomat that exempts them from the laws of a foreign jurisdiction. It must be noted that immunity is a privilege of the state that a diplomatic agent represents. As such, a person cannot allege breach of immunity if the sending state does not contest a violation. The Vienna Convention on Diplomatic Relations, 1961, which most countries have ratified, offers diplomats acting as officials of state almost total protection from subjection to criminal, administrative, and civil laws belonging to the country in which the diplomatic mission is located. Diplomats assigned to missions located in foreign countries remain subject to the laws of their home countries. The diplomat's country of origin has prerogative over whether or not a host country may prosecute a diplomat under its, i.e. foreign, laws. The Diplomatic Relations Act of 1978, 22 U.S.C. 254 et sec. Governs diplomatic immunity in the United States. Title 22 specifies the degree of protection awarded to diplomatic personnel. Protection increases in parallel with the official status within a diplomatic mission. Article 31 of the Vienna Convention provides for 3 exceptions to the diplomatic immunity, which are as follows. A real action relating to private immovable/tangible property. An action relating to succession. An action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official functions. Diplomatic immunity, a principle in international law, grants foreign states, international organizations, and their representatives immunity from the jurisdiction of the host country. This ensures envoys can perform duties without fear of coercion or harassment. These agents and their families are protected from arrest and prosecution, and are largely exempt from the host country's laws. The receiving state must protect embassies from intrusion or damage. The Vienna Convention on Diplomatic Relations, 1961, codified many of these protections. Diplomatic immunity, rooted in international law, grants special rights to foreign diplomats in their host country. This ensures they can perform their duties without fear of coercion or harassment. Heads of missions and their aides typically receive these privileges and immunities. Protections include inviolability, safeguarding them from arrest or detention, even during war. They are generally exempt from the host country's criminal and civil laws, taxes, and military obligations. The property of the mission, such as the embassy, is also inviolable. Diplomatic immunity is rooted in the acknowledgement of the necessity for open communication and contact between nations. It ensures that diplomats can perform their duties without fear of coercion or harassment by the host country. These protections developed over centuries through custom, religion, and treaties, evolving into modern international law. The Vienna Convention on Diplomatic Relations, 1961, codified these practices, granting diplomats and their families immunity from criminal prosecution and some civil jurisdiction. This promotes effective international relations by ensuring diplomats can fulfill their roles without undue interference. Diplomatic immunity in international law gives diplomats special rights and protections in the country where they are working. These rights and protections ensure diplomats can perform their duties without fear of coercion or harassment. Diplomats and their families are inviolable and not subject to arrest or detention, even in times of war. Their homes are also inviolable, and they are largely immune from the host country's criminal and civil jurisdiction, though missions may waive some exemptions. A foreign envoy is free from taxes and military obligations in the host state. The host country does not inspect their personal baggage and household effects. The sending state's flag and emblem may be displayed on the embassy, residence, and vehicles. If a diplomat breaks the law in their host country, diplomatic immunity usually protects them from criminal prosecution and some civil jurisdiction. However, this immunity isn't absolute. The host country can declare the diplomat persona non grata and expel them. While diplomatic immunity offers protection, it doesn't mean diplomats are above the law. Their home country can prosecute them. Additionally, the diplomat's government can waive their immunity, allowing the host country to prosecute them. International laws and agreements, such as the Vienna Convention on Diplomatic Relations, shape diplomatic immunity by codifying the rights and protections diplomats receive in host countries. Diplomatic immunity, a principle of international law, ensures foreign diplomats can perform their duties without fear of coercion or harassment. These immunities, rooted in custom and reciprocity, have evolved over centuries and are now formalized in treaties and national laws. The Vienna Convention is a key instrument, outlining the scope of these privileges and immunities, including protection from criminal prosecution and some civil jurisdiction, for diplomats, their families, and staff. Diplomatic immunity: in international law, the immunities enjoyed by foreign states or international organizations and their official representatives from the jurisdiction of the country in which they are present. The inviolability of diplomatic envoys has been recognized by most civilizations and states throughout history. To ensure exchanges of information and to maintain contact, most societies, even pre-literate ones, granted messengers safe conduct. Traditional mechanisms of protecting diplomats included religious-based codes of hospitality and the frequent use of priests as emissaries. Just as religion buttressed this inviolability, custom sanctified it and reciprocity fortified it, and over time these sanctions became codified in national laws and international treaties. Protections afforded to foreign envoys varied greatly in the ancient world. Greek heralds, who were recognized as inviolable by the city-states, procured safe passage for envoys prior to negotiations. Typically, the inviolability of envoys was not respected by third parties. As empires in China, India, and the Mediterranean grew more powerful, diplomatic protections decreased. The law of diplomatic immunity was significantly developed by the Romans, who grounded the protection of envoys in religious and natural law, a system of norms thought to apply to all human beings and to derive from nature rather than from society. In Roman law, the unassailability of ambassadors was guaranteed even after the outbreak of war. During the Middle Ages in Europe, envoys and their entourages continued to enjoy the right of safe passage. A diplomat was not responsible for crimes committed before his mission, but he was answerable for any crimes committed during it. During the Renaissance, permanent rather than ad hoc embassies developed, and the number of embassy personnel, as well as the immunities accorded to them, expanded. When the Reformation divided Europe ideologically, states increasingly turned to the legal fiction of extraterritoriality, which treated diplomats, their residences, and their goods as though they were located outside the host country to justify diplomatic exemption from both criminal and civil law. The doctrine of quasi-extraterritorium, Latin, as if outside the territory, was developed by the Dutch jurist Hugo Grotius, 1583–1645, to sanction such privileges, and during the 17th and 18th centuries other theorists turned to natural law to define, justify, or limit the increasing number of immunities. These theorists used natural law, with its appeal to universal moral injunctions, to argue that the representative nature of a diplomat and the importance of his functions, especially that of promoting peace, justified his inviolability. The same moral law underscored his obligations to the larger community. Because immunities varied greatly between jurisdictions, and because some jurisdictions offered few if any immunities, to protect their envoys countries increasingly resorted to laws such as the Act of N. 1709, in England, which exempted ambassadors from civil suit and arrest, or treaties such the 17th-century agreement between England and the Ottoman Empire that forbade searches of the British Embassy, exempted the servants of embassies from taxes, and allowed the ambassador wine for his own use. Although the French Revolution, 1789, challenged the basic foundations of the Ancien regime, it reinforced one of its hallmarks, diplomatic inviolability. By the late 19th century, the expansion of European empires had spread European norms and customs, such as diplomatic immunity and the legal equality of states, throughout the world. Because of the increasing number of privileges and immunities enjoyed by envoys, some theorists sought to undermine the concept of extraterritoriality by highlighting its attendant abuses, such as the granting of asylum in embassies to notorious criminals and smugglers. In particular, legal positivists who argued that the law of diplomatic immunity should be based on treaties and precedents strove to reduce what they considered the excessive privileges of envoys. By the late 19th century, positivists were dominating international jurisprudence, largely because they avoided the problem, characteristic of natural law theorists, of confusing international morality with international law, and because they based their theories on the actual practice of states. The position of diplomats and the public respect they enjoyed declined substantially in the 20th century. This development, combined with certain other factors including the explosive growth in the number of new states after World War II, an increase in the size of diplomatic missions, and the increasing prevalence in international law of the view known as functionalism, according to which diplomatic privileges should be limited to those that are necessary to enable a diplomat to accomplish his mission, led eventually to attempts to restrict diplomatic immunities in international treaties. The Vienna Convention on Diplomatic Relations, 1961, restricted the privileges granted to diplomats, their families, and staff. Avoiding controversial issues such as diplomatic asylum and focusing on permanent envoys rather than on ad hoc representatives or other internationally protected persons, the convention accorded immunity from criminal prosecution and from some civil jurisdiction to diplomats and their families, and lesser levels of protection to staff members, who generally were given immunity only for acts committed in the course of their official duties. Since the 19th century, diplomatic privileges and immunities have gradually been extended to the representatives and personnel of international organizations. Despite these developments, from the late 20th century, diplomats and representatives of international organizations continued to be subject to prosecution and officially sanctioned harassment in some countries, a situation perhaps best exemplified by the seizure of the U.S. Embassy in Tehran, Iran, in November 1979 by supporters of the Islamic Revolution in that country, and the holding of more than 50 American diplomatic personnel as hostages for 444 days. Thank you for watching this video.